Hello, everyone, and welcome back to the IDPC Podcast, the series where we update you with the developments in data protection ecosystem in the EU and beyond. I'm your host, Franco Loisio. I'm the head of communications of the IDPC. Today, we're joined by Ian Deguara, the Information and Data Protection Commissioner. Welcome, Ian.
Welcome, Franco. Thank you very much. And I say hello to our guests and listeners.
We're here to examine a recent topic, the European Commission's Digital Omnibus proposal and the joint opinion on the matter adopted by the European Data Protection Board, the EDPB, and the European Data Protection Supervisor, the EDPS. The opinion addresses key aspects of the proposal aimed at simplifying and modernizing the EU's digital regulatory framework, including proposed amendments to the General Data Protection Regulation, the GDPR. So let's go to the questions. To start us off, the European Commission published the Digital Omnibus, as we referred to earlier, on the 19th November 2025. Can you explain what the proposal actually is, its objectives, scope, and why it is currently subject to wide discussions across the EU?
So, thank you, Franco. Before I answer the question, I think it is very pertinent to give some background and some context to all this. So, let's move the clock a little bit backwards. So, we go back to September 2024, where there was what's called the Draghi report. So, this report, which was prepared by Professor Mario Draghi, who was a president of the European Central Bank, and he was Prime Minister of Italy as well. And he was tasked with this very important mandate to prepare this report, which was published in September 2024. Actually, Mr. Draghi identified three necessities, actually, in that report in order to boost the competitiveness of the European Union. And he identified as a first necessity the importance to close the innovation gap. The second one was to decarbonize the economy. And the third one was to reduce the dependencies on external markets. Following that report, in January of last year, 2025, the European Commission, to action that report, published what is called the Competitiveness Compass, which is another report which actually took into account these three necessities and identified then 5 horizontal enablers. One of which, and I'm saying this because it ties in with what we're going to discuss later on in this podcast, was to cut red tape. Red tape in order to reduce administrative burdens, particularly on SMEs, to strengthen the economy, to ensure a more resilient economy given the geopolitical situation, and more importantly, to simplify. So the key word is simplification here. Following that, the European Commission started issuing what is called omnibuses. Omnibuses are legislative vehicles how to introduce targeted changes in order to achieve this simplification. There were a number of omnibuses, and now I'm going to speak directly to those relating to the GDPR, because the first amendment, which was introduced to the GDPR before the Digital Omnibus, it was by means of the fourth omnibus. It's called the fourth omnibus, where the European Commission in May 2025 made changes to Article 30 of the GDPR, the one relating to the records of processing activities. And by means of that omnibus, the targeted change in that respect was that the threshold for employees, for the number of employees employed by controllers, and therefore those which were not required to do the records of processing activities, went up from 250 to 750. And the exemption, therefore, for those controllers who were not required to do this record of processing activities was only insofar as high-risk activities within the meaning of Article 35. So that was the first amendment which was introduced by the Commission by means of the fourth Omnibus. A little bit of fast forward, July 2025, we as European Data Protection Board adopted the famous statement, it's called the Helsinki Statement, where we recognized the importance of all what was happening, of all these developments happening within the European Union, the key notion of competitiveness in particular, and therefore we have adopted this statement, keeping all this in mind and ensuring and giving the necessary assurances to controllers out there and the general public that we as a board were cognizant of all these facts and therefore we're going to assist controllers in their compliance efforts, and this was going to be done by means of producing less complex guidelines, more user-friendly guidelines, having less legalese, having more examples.
Always to simplify.
Exactly. Providing formal templates, because templates are a very useful tool, particularly for small organizations, SMEs. And in Malta, we have the majority of companies which are SMEs. We have also startups as well. Secondly, we, as board in the statement, committed ourselves that we were going to engage with the public. And this is where we were going to have the stakeholder engagement. So before preparing guidelines or before taking a position on certain important matters, take AI in particular, or the notion of pseudonymization, we committed ourselves that we hold a priori a stakeholders event so that we listen. It will be open to everyone and we will listen to what the general public, controllers, organizations, civil society were going to tell us, and then we will take into account that in the formulation of our position. That was the second point. And the third one was the engagement with other regulatory bodies for cross-border, for cross-regulatory affairs. And in this regard, we made sure that in that statement, our commitment was clear that where there are other legal frameworks, mentioning Digital Services Act, AI Act, Digital Markets Act, we were going to engage with other bodies or with other regulatory authorities so that we can inform ourselves and we can together develop the guidelines jointly. And then there was on the 19th, as you correctly said, on the 19th of November 2025, the European Commission presented the Digital Omnibus. It not only amends the GDPR, but also amends other pieces of legislation. In particular, the e-Privacy Directive, NIS2, Digital Services Act, Digital Governance Act, and so on. So this is where we are coming from with this Digital Omnibus.
Quite a lot of background and work already carried out.
No, because I think it is very important for our listeners and viewers to give them this context, because the Digital Omnibus didn't fall from the sky like a bomb like that, Yes. So there was a series of events which led to this.
The EDPB, as we mentioned, as well as the EDPS, were requested by the European Commission to give their opinion on the proposal. We already referred to it. What are the main points which are covered under this joint opinion?
So in this joint opinion, So it's a joint opinion because the European Commission has requested both the European Data Protection Board and also the EDPS to issue their opinion. This is why we have jointly issued it, and the request was made on the 25th of November of 2025. And we have issued it together with the EDPS because the EDPS is our counterpart, but who is responsible for European institutions and bodies. The joint opinion is divided into three main areas. So there are areas, there is the first area on which we welcome the proposals made by the Commission. Now I am speaking only to those proposed amendments within the Digital Omnibus which deal with the GDPR. So there are those proposed amendments to which we welcome, because they are intrinsically good. They provide for more legal certainty. They do indeed facilitate. They create a more simplified environment for data controllers. Then there are those proposed amendments which we support. We understand the underlying rationale, but on which we have some reservations, and therefore we are making concrete and proposed amendments to the co-legislators eventually. And then there are those proposed amendments which are a red line to us, and which we are saying that we have serious reservations about these proposed amendments, and therefore this is why they constitute a red line for us.
Okay, one of the most debated proposed changes in the Digital Omnibus concerns the amendment to the fundamental GDPR's definition of personal data, which a joint opinion warns could narrow the scope of the law and reduce protections if adopted as drafted. The joint opinion strongly urges lawmakers not to adopt these proposed changes. Could I have your take on this?
In fact, indeed, this is the third category which I mentioned. That is the ones, so those proposed amendments which to us are a red line. And in particular is the proposal where the Commission is making changes to the definition of personal data. Whereas we recognize that the intention was to align the definition which we currently have in the GDPR with the judgments of the Court of Justice of the European Union, we firmly believe that these amendments do go actually beyond the various rulings which were pronounced by the Court of Justice of the European Union. And this would mean that rather than the proposed amendment being a targeted change, because let's remind our listeners that the scope behind the Omnibus is to make targeted amendments, not to reopen the entire legal framework, just to make a targeted amendment to simplify and cut red tape and provide more legal clarity and certainty.
Not address fundamental issues.
And not address fundamental issues, because when we speak about the notion of personal data, the definition of personal data, it is a core definition. Yeah. I mean, a definition which we had for so long now, and on which there are various rulings from the Court of Justice of the European Union. Therefore, our position and this is expressed clearly in the joint opinion, is that this definition should not be touched. We believe that, and we are advising the co-legislators, that the proposed amendment should not be taken on board during the legislative exercise, because it is a fundamental change. So what is being proposed is a fundamental change, and this goes actually beyond. So together with that, the Commission also proposed that they will adopt implementing acts, they are called, implementing acts, where the Commission will identify those instances where data, personal data, which has been pseudonymized, will or will not continue to constitute personal data. And in that regard, we are also saying, no, it shouldn't be the Commission to make these determinations. This should be left in the hands of independent data protection authorities when they are examining, investigating cases, and ultimately in the hands of national courts and European courts. It shouldn't be the European Commission to identify those cases and adopt implementing acts in this regard. So this is our position, which is very clear. And on this, I can tell you that even during our European Data Protection Board meetings, I mean, we are all on the same page on this.
An extension to this question, can you provide our viewers and listeners with some more information on the position of the EDPB and the EDPS as expressed in the joint opinion relating to other proposed amendments made by the European Commission to the GDPR?
Yeah. Because, I mean, we have mentioned only this one, the negative, let's call it the negative one, but there are more proposals which have been made by the European Commission. And as I said at the beginning, there are those which we welcome and the other ones which we support, but with some caveats, you know. So the changes which we welcome, for instance, are that, and with this we do fully agree with the proposed changes by the Commission, the definition of scientific research. So now there is a proposal to introduce in the GDPR a definition of what is scientific research. Together with that, there is another proposal where it is being stated that the compatibility tests should not be done when data is further processed by or for the purpose of scientific research. So this is something which complements that. And the third one is an exemption from providing data subjects. So these are all related to the notion, to the issue, to the changes in relation to scientific research. The third one is a proposed amendment to the GDPR where the Commission is proposing an exemption from providing information to data subjects when their personal data is used for scientific research, because it might involve a disproportionate effort, because it might negatively affect the scope of the research. So in those cases, there will be an exemption from providing information under Article 13 to the data subjects. So this is the first one which we welcome in the joint opinion. The second one, I'm going to mention them all. I'm going to stick to 2 or 3. The second one is the one or those proposed amendments relating to the notification of personal data breaches. The proposed amendments, which we also welcome as EDPB and EDPS, are an extension to the time frame to submit a data breach notification by controllers, so from 72 hours to 96 hours. There is an increase, so there is a proposed change also to increase the threshold for when a controller is required to notify a breach, because currently the threshold is where there is a risk to the fundamental rights and freedoms of individuals. Now, by means of that, of the amendment, the threshold will go up. And only those breaches, those personal data breaches, those security incidents, which affect or have an impact, a high-risk impact on the rights and freedoms of affected data subjects, must be notified to supervisory authorities. So in this regard, and we have also agreed with this proposed amendment for the simple reasons that we as DPAs were being inundated with incident reports, with personal data breach reporting, notifications, which were really petty, which were really insignificant, where there were actually no risks to the rights of data subjects. So now, even though, in spite of the fact that it is incumbent on the data controller to conduct a risk assessment always. So when a controller suffers an incident, a breach, they are required to conduct a risk assessment. And there are methodologies. For instance, the ENISA one, it proves to be a very good methodology how a controller can assess that risk and determine, therefore, the risk level. But now, by means of this amendment, the risk level will go up. So only those breaches, those incidents, which are of a high risk within the meaning of Article 35, which must be notified. Also, together with that, there will be a single entry point for notifications. Why? And this is something which we have also mentioned in the Helsinki Statement and which we agree to. Controllers are subject to various pieces of legislation. So let's mention a bank, for instance. They are subject to DORA, they are subject to Cyber Resilience Act, they are subject to GDPR, they are subject to NIS2. So, and in all of these legal frameworks, there is actually a requirement to notify to the competent authority an incident, a security breach, you know. So what the Commission is proposing, and what we have also proposed in our Helsinki Statement, is that the organizations will only have one single point of entry for notifications. So they will only make one notification on one platform. We will have to see the mechanics, how this will be implemented eventually. But discussions are already being held at European level. And then that notification or the relevant parts thereof will be channeled to the respective authority. So, for instance, those parts relating to GDPR will come to us. But the notion here is that it will facilitate. So this is the issue, the simplification objective, that for those organizations, they will only have to notify one form, and then that form in one single entry point, and that form then it will be channeled to the respective supervisory authorities. So these are changes which we have welcomed and which we agree with, and these are all spelled out in the joint opinion. But then there are some other proposed amendments which we are supporting. We are understanding the underlying reasoning, but naturally we are expressing our reservations and concerns, and we are not stopping there, Franco. We are saying, look here, the co-legislator should, yes, we agree in principle with this, but should make these amendments to the text, to the recitals, to the operative text, in order to align it more with our guidelines, with the positions or with the rulings of the Court of Justice, with the rulings of national courts, So, and to give you an example, for instance, the Commission is proposing to introduce a derogation under Article 9 for the processing of special categories of data for the development and deployment of AI systems. So there will be the use of these special categories of data, to remind our listeners and viewers, are those data relating to health, philosophical beliefs, racial, political opinions. Those all constitute special categories of data. So the proposed amendment, however, is for controllers to provide for a derogation, so they will be allowed to use these kind of data for the development and deployment of AI systems. What we are saying in the joint opinion is that we have already recognized that this may be done in conjunction with Article 6.1f, the legitimate interest criterion under the GDPR, but there is no need to introduce a further exception, derogation in this respect, because we have already recognized it. Controllers can still use the present derogations and the legitimate interest by conducting the three-part test, so on and so forth. And therefore, in this respect, we are saying, whereas we recognize the intention, the good intentions, but we do not believe that this should be in the new text, which will be then discussed between the co-legislators. Apart from that, there are other changes. So, for instance, there are changes relating to the abuse of rights of access by data subjects, which we are agreeing, but then we are saying we need to be careful because the right of access is a fundamental right. It is entrenched in Article 8 of the Charter of Fundamental Rights and Article 16 of the Treaty of the Function of the European Union. And therefore, whereas we recognize that there might be abusive requests, but this should be the exception, you know. So these are also other changes which are being proposed and on which we are pronouncing ourselves in the joint opinion. I'm not going to mention all the others. I mean, perhaps when we upload this podcast, we can provide the link to the joint opinion, and perhaps our viewers can have a more in-depth look and analysis in the document.
Quite a mixed bag. The joint opinion expresses a clear message. Simplification should not come at the expense of fundamental data protection rights. We already mentioned this, as well as legal clarity. Why do you consider that this message is so important?
As I mentioned before, the scope of the omnibus is to introduce targeted amendments, not to open up the entire legal framework. You know, in particular, if there are issues of a substantive nature, of a fundamental nature, and therefore what we have said also in the joint opinion is whatever targeted change is done to the GDPR in particular, because there are proposed amendments to other pieces of legislation, must not lower the protection of fundamental rights to the protection of personal data in relating to personal data.
That's the fundamental issue.
So this is the fundamental issue. So whatever change is made, okay, we agree to simplify, we agree to reduce red tape, we agree to provide more legal clarity and certainty, which are all positive objectives. But in the process, and this is the message which we wanted to give out to the co-legislators in particular, is that these amendments should never and must not lower the protection of fundamental rights. And why? And this is my personal take on that. Because we speak a lot about the Brussels effect. What is the Brussels effect? The Brussels effect is we have the GDPR. We used to call it the golden standard of the protection of personal data. And this golden standard was adopted by other countries. So Latin America. So it's at the benchmark. So now when these countries, you know, which either didn't have a legal framework for the protection of personal data, or had one and they have adopted it or adapted it, you know, to meet the high standards, you know, and now these countries have these high standards, we shouldn't lower them now. And you know what I mean? So we should keep those standards, while at the same time we simplify. I agree, we simplify because it is good to ensure we have a more competitive market, stimulate economic growth and these sort of things, cut red tape, you know, but still the standards should remain up there.
I suppose it's a question of compromise. To the final question, now after the joint opinion of the EDPB and the EDPS, what will happen in terms of the legislative process to the Digital Omnibus?
Yep. Let's remind our viewers, first of all, that these are just, at the time being, proposed amendments. The current legal framework, so the General Data Protection Regulation, remains applicable. So we shouldn't run and say, look, yes, now we don't need to notify high or low risk personal data breaches because we will only be required to notify high risk. No. The current legal framework, the current obligations do still apply. So now there has been the Digital Omnibus, the proposal in the form of a regulation. And there will be what we call the ordinary legislative procedure. So there will be now the position of the Council, the general approach by the Council. There will be the position of the European Parliament. And then the trialogue, what we call the trialogue meetings will start between these three co-legislators, the Commission, Council and the Parliament. And then they will have to meet at one point. They will have to compromise. We call it the compromise text. So it will take some time. So we are envisaging, or we are hoping that this process will end by the end of 2026 of this current year. But never say never. I mean, the GDPR took 4 years of discussions to reach. So from 2012, let's remind you, the first proposal by the Commission for the GDPR was in 2012. But then the GDPR was adopted and it came into force in 2016, so 4 years after. And there were thousands of amendments to the text. So this process might look simple, as it sounds, but actually it will involve a lot of negotiations in order to reach to that compromise text. So once that the compromise text will be agreed, then that legislation, the regulation, will be adopted. Most probably there will be a transition period following the adoption, the coming into force, and there will be a transition period, and then the regulation will become applicable. So this is what we are foreseeing to happen in the coming months. Let's hope by the end of this year, 2026, if not, hopefully not more than by mid of 2027.
Thank you, Commissioner Deguara, for your insights and thoughtful perspectives.
Always my pleasure.
On the Digital Omnibus and the joint opinion, it's clear that while simplification can bring benefits, safeguarding individual rights remains a central pillar of GDPR and the EU Digital Rulebook, as we can summarize here. To our listeners, thank you for tuning in to the IDPC podcast. We hope today's discussion helps you stay informed on how the EU policy developments could shape the future of data protection and digital rights. Thank you, and see you next time.